live stream. And Mr. Pika and Mr. Roth, greetings.
Good afternoon, Your Honor.
And we
I
are
apologize for my tardiness.
no problem. We're here. Mr. Roth kept me apprised, and we are here for the Dundas case. Is that correct?
Yes, sir, Your Honor. Yes, sir.
And how do the parties wish to proceed?
Your Honor, if it's okay with the courts, I believe we're gonna hope to enter a plea today with a preferred sentencing.
Very well, Ms. Dundas, if you can come up and join your counsel. This is 18 CF 73. Hello, Ms. Dundas, welcome back.
Hello.
Mr. Roth, your comments?
Judge, that's what we would like to do.
Okay.
We have a negotiated agreement, but some conditions will be met by September, at which time
Very
we'd
well.
like the court to sentence.
So we'll do the plea colloquy, is that correct?
We will do the plea colloquy, enter the plea, and we're asking for a sentencing date in September.
All right, and I can provide that at some point during our discussion here. We'll set it either September or October, whatever the parties prefer.
Very good, Your Honor.
All right, and counsel, do you wish to announce the terms either side?
Your Honor, it's the defendant is going to enter a plea of guilty to one count of trafficking in cocaine, 400 grams or more, which is 893.135, subsection 1, subsection B, 1C.
That's as currently charged.
It is as currently charged. And in consideration for substantial assistance, the defendant will be adjudicated guilty. She will have a $50,000 fine, which will be reduced to a civil judgment. There'll be the cost of the court. There'll be a cost of prosecution in the amount of $3,448.57. That will be a condition of probation. The defendant will serve a 3-year minimum mandatory sentence to be followed by 5 years of state probation. She will have a 1-year driver's license suspension and be required to submit a DNA sample. And Your Honor, just so the court understands, from today until the time of sentencing, she'll have the opportunity to better her situation.
Okay. So these terms may be revisited depending on the circumstances in September, October, wherever the
I
parties.
believe that's the hope of Mr. Roth. Absolutely, Your Honor.
Mr. Roth, clarifications?
No, Your Honor, I believe that's accurate.
All right. Ms. Dundas, have you had sufficient time to speak in private with your counsel about this important decision?
Yes, I have, Your Honor.
Do you believe it is in your best interest to accept the terms as announced?
Yes, I do, Your Honor.
Do you have any additional questions?
No.
Please raise your right hand and be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth? Yes, I do.
Thank you. Ms. Lawyer Hand, please answer the state's questions.
Ma'am, can you please state your name for the record?
Michelle Fernandez,
And what is your date of birth?
6/17/92,
What are the last 4 digits of your social security number?
3417.
Do you know why you were here?
Yes.
You are charged with trafficking in cocaine, which is a first-degree felony punishable by up to 30 years in prison. Do you understand that?
Yes.
You understand as currently charged that that statute carries a $100,000 fine and a mandatory minimum sentence of 7 years?
Yes.
What level of education have you achieved?
Pardon?
What level of education have you achieved?
High school diploma.
Can you read, write, and understand the English language?
Yes.
Have you ever been diagnosed with a mental illness?
No.
Are you currently under the influence of any alcohol, drugs, or controlled substances
No.
that may impact your understanding of this proceeding?
No.
Do you understand that when you enter a plea, you give up your right to a jury trial?
Yes.
That means a jury will not determine your guilt or innocence.
Yes.
That means your attorney will be able to ask questions of the state's witnesses.
Yes.
That means you won't be able to call your own witnesses or present your own evidence. You understand when you enter a plea, you're giving up all those rights. Are you happy with your attorney?
100%.
Okay. He answered all the questions you had about the case?
Yes.
He explained the minimum and the maximum for what you're facing?
Yes.
He explained the significance of entering a plea today and deferring sentences for a later time.
Yes.
Do you understand if nothing occurs, you'll be doing a 3-year minimum mandatory followed by 5 years of probation?
Mr.
Is there
Pica,
anything more you want from your attorney before you went to this plea today?
Mr. Pica, just one clarification, please. You did mention a 7-year minimum mandatory at some point. How does that compare to the 3 years agreed to in terms of clarifying that?
Okay. The statute that she's currently charged with, that she's entering a plea to, has a $100,000 fine and a 7-year minimum mandatory. But due to the fact that this is a substantial assistance agreement, the state's allowed to go below that in resolving the case. So we're going to resolve it for the $50,000 fine and the 3-year min-man, even though she's charged with the $100,000 fine, 7-year min-man, but we're allowed to do that considering the posture of the resolution.
Okay, thank you.
Just one moment.
Sorry to take you out of your game.
No, it's okay. It's okay. Jury trial, you're happy with your attorney, explain the minimum or maximum. Have you been promised anything other than what we're talking about here today in order to enter this plea?
No.
Have you been forced? Have you been threatened? So you are entering this plea because you are in fact guilty.
Yes.
And you agree that you were transporting an amount of over 400 grams of cocaine at the time of your arrest?
Yes.
Okay. Do you understand that if you're not a U.S. citizen, this plea will lead to your deportation?
Yes.
Do you understand that if the crime to which you are pleading to is sexually motivated or sexually violent, or if you had previously pledged for a crime of that nature, that this plea could lead to your involuntary civil commitment as a sexually violent predator upon completion of your sentence?
Yes.
Do you have any other questions or concerns before we move forward? Does the defense counsel stipulate to a factual basis in their venue lies here in Collier County?
I do.
Your Honor, I believe I've covered all the issues for the colloquy. I now tender to your Honor for the acceptance of the plea. I have a score sheet here. Would you like to see it?
Sure.
I also have a couple orders here, but I think they're meant for sentencing. Do you want to keep them in the court file?
No, if you just want to present those later.
Very good, Your Honor.
Mr. Roth, any additional comments?
Ms. Bendis did fill out a rights waiver.
All right, I will take the plea form at this time. It's my recollection that there was a substantial motion to suppress in this case at one point, was there not?
Judge, it was a speedy trial issue,
Oh, there was a speedy trial.
went up to the district court. Your Honor was affirmed that decision.
Is the defense waiving any right to further appeal that matter as part of this plea agreement? Or is that?
We are waiving that
All right,
right. This is not a conditional plea.
all right. Anything else at this time from either counsel?
No, Your Honor. I would imagine the defense wants as long as you're possibly willing to give.
And just for clarification, in the very unlikely event that I think in fairness to Ms. Dundas, it should be clarified, in the very unlikely event that there should be any substantial new law violation or a failure to provide substantial assistance, what is the position of the parties then in the fall?
Your Honor, we
Please.
discussed this in the room before we entered the courtroom. At that point, we would ask that the tendered plea that has been conveyed to your Honor will stay. We
However,
wouldn't be looking for a 30-year sentence. We'd be looking for the 3 followed by 5.
Mr. Roth, what's your understanding?
That's my understanding, Your Honor, that if she's unsuccessful in what she hopes to do, she would come back here and if Your Honor agreed with the parties, she would receive a 3-year followed by 5 sentence.
But Mr. Roth, I believe the judge was asking if she was to happen to have the misfortune of being arrested again. And we said it would be the negotiated plea.
She would receive the negotiated plea. I agree with that.
All right, then at this time, the court finds that the plea is freely, voluntarily, intelligently made with advice of counsel, and Ms. Dundas, having been informed by her counsel of her options, has chosen to resolve the case with this plea agreement, understanding that it is still subject to a contingency and a deferred imposition of sentence. The court will approve the plea agreement provided that everything is followed through. Mr. Roth, what month do you wish to return to complete this?
If the court would give us a date in October.
Any objection, Mr. Pica?
No objection, Your
All
Honor.
right, let me just go ahead and set that now.
Am I doing anything?
No, ma'am.
One drink, so I'm not doing nothing, just second.
I would think you would put in the fact that she had been pleaded guilty and was adjudicated guilty, and nothing else.
Oh,
Molly, concern.
Manalich's office.
Hello, Melissa. We're going to need a date from you in just a moment. I'm concerned it would affect her bond if any adjudication is entered, Mr. Pica. I would just simply accept the plea colloquy and indicate that we'll
That's fine,
defer
Your Honor.
imposition of sentence
No
so
problem.
that she may remain at liberty in the meantime,
Thank you.
No
without
problem, Your Honor.
any impact on the bond. How much time may be needed in October?
30 minutes.
Okay, so Melissa, we're looking for return to court of Ms. Dundas to have sentence imposed, and it at maximum would take 30 minutes.
Okay.
You could look for a date and see if both sides are available. While she's doing that, Madam Clerk, you need any clarifications any further?
no, Judge. So I'm just gonna plead her guilty to all 4 counts, and when you come back, you'll get rid of the other 3, right?
I believe there's only one count.
I
Okay.
have 4 counts up here.
Yeah, I was going to ask about that also. There are some other counts charged. Did the parties reach an agreement, or were those somehow dropped along the way?
I just don't know what you're referring to, Your Honor, which was the one count information.
Okay, let me just double check.
Okay.
Your Honor, you did bring something up that I think I should, so like I said, I was out of town for work last week, which was part of the confusion for this morning.
That's why they call you the statewide prosecutor.
However, I do believe there might be an issue with Ms. Dundas's bond. It may have possibly expired due to the fact that it's over the 3-year period. I can't be positive. I think I may have seen an email or something to that nature. So I don't know if you want to comment on it. I don't have a, I don't have a problem with the same type of bond being in place or being on, released and sentencing.
Mr. Roth, clearly it's the intention of the parties in the court to have Ms. Dundas remain at liberty while this is pending, but is there a complication with the bond that you're aware of?
I mean, it's a very old case. It may be that the bond was posted more than 3 years ago.
Any recommendation as to how we should address it?
I would like the court, if that's the case, to allow her our release. She's never missed court for years. She's being supervised in terms of her assistance by a federal law enforcement agent. And she's already accomplished something, and she hopes to accomplish more in an investigation that is already ongoing. But she's financially exhausted at this point.
What's the state's position, Mr. Pika?
I don't have a position, Your Honor. I don't have concerns of upping the jurisdiction.
So there's other things in place that would satisfy the state as to her availability for future proceedings?
I believe so, Your Honor.
It will be a hardship on Ms. Dundas to have to repost a bond, is that correct?
It would, Your Honor, she doesn't have that ability.
Does the state want any conditions attached to any release on her recognizance with any other conditions you would recommend?
Your Honor, I forgive you for bringing this up at a late date. I'm now looking at a motion signed by an attorney by the name of Jorge Della Villa, which is a stipulated motion to discharge a surety in the case, which is the reason I brought this topic up.
Okay, I didn't get a copy of that, but, Your Honor, Ms. Douglas is a U.S. citizen with a United States passport. I would offer to the court that I could either take possession of the passport, or I could provide it to Mr. Antica, or I could deposit it with the court if that would add security.
Your Honor, if Mr. Roth would take possession of the passport, that would satisfy the state of Florida.
Okay, so Ms. Dundas to immediately surrender any travel documents, including passports or visas or any other type document of that nature, to Mr. Roth to be held in trust during the pendency of the proceeding.
And once I have it, Your Honor, I will file a notice.
All right. Any other conditions requested by the state, such
That
as
should suffice,
restrictions?
Your Honor.
No other restrictions on travel?
Well, I don't think she's leaving the country without a passport.
Right, so you're okay if she's outside the state of Florida?
I have no objection.
Then at this time, the state is not objecting under these circumstances to release on her own recognizance forthwith at this time with the condition of surrender of travel documents.
Yes, Your Honor.
I think we'll need, Madam Clerk, a order here from the both counsel, is that correct?
For the bond,
Right. Right now, you're still listing her as having the previous bond in place?
I do, and the 4 charges. She was arrested on 4, but you guys only filed on 1, so that's leaving 3 still outstanding.
So there's never been a disposition of the other 3 that
No.
or she was arrested for? I do see that your information only charges the trafficking, but we do have 3 other arrest charges that apparently were not disposed of. It's the state's intention to,
Not move forward on them, Your Honor.
are
So
you
you
gonna,
want me to know cross those now? I can do.
Well, I mean, they never been charged, so it wouldn't be a no process, probably be a no file.
No, it's okay.
do you wish to, are you gonna file something on that, or just have the clerk noted from here?
I was hoping the clerk could resolve it from here.
Okay, I can.
Okay.
And you guys did she's a motion for ROI.
Well, we have pending apparently, or has it already been ordered? We have pending from other counsel with regard to the bond.
I have a motion to discharge a surety that I have not addressed it.
Okay. And do you want to address that now or later when it's set? And-
Well, it was a stipulated motion. I don't have the ability to sign it and submit it at this time.
Okay.
I
Do you
can
want,
say that I don't have an objection to the surety being dismissed.
Madam Clerk, in terms of, for the clerk's administration, what is the easiest thing to do for you? To have 2 stipulated documents submitted at the same time, one essentially, for lack of a better term, terminating or canceling the previous bond and replacing it with the ROR and travel document condition?
That's what I'm gonna do.
Are the parties able to do that jointly then, as one submittal?
Yeah, Your Honor, when I go back to the office, I will sign that stipulated motion, and I'll CC Mr. Roth, and then Mr. Roth is going to take possession of the passport, and maybe he'll create a stipulated document talking about being released on ROR, but for the passport.
Yeah.
So I would hope that by the end of business tomorrow, we should be able to get you all done.
Just so we don't have a gap that makes the clerk uncomfortable there, if it's a joint submittal like that, Madam Clerk, will that suffice? All right. So let's say if you can just present them, I would request we could do that this week, but by Thursday at the latest.
I'm hoping by the end of business tomorrow, sir.
Okay, all right. And Melissa, have you found an October date for us?
October 7th at 9 o'clock.
Let me see, do you have a later date that might also work? Can you check for a later October date?
I'm looking right now. We would have to go into November.
So what does the state prefer?
I would take October 9th. I would ask if there's a later time in the day.
That's the 7th.
But she said October 9th.
October 7th at 9 o'clock.
And is there a later time on 7th?
Will the parties be appearing in person?
Well, that should be the sentencing.
Right.
So yes.
Yes, okay. So, Melissa, any possibility, same for Mr. Roth, you would prefer the afternoon also?
Oh, the afternoon, October 7th at 1:30.
That's fine.
That
That's wonderful, sir.
works for everybody, and everybody will be in person then?
We'll be in person.
All right. So that'll be for imposition of sentence, Melissa.
Okay,
We're also going to be receiving by no later than Thursday, probably tomorrow or Wednesday, a document. So it'll be coming from you, Mr. Pico, or both sides?
One from me, one from Mr. Roth.
So both Mr. Roth and Mr. Pico will be submitting documents regarding the bonds in the situation. The previous ones are going to be ended, and there's going to be a new ROR with condition bond.
okay.
And those will need to be presented together to the clerk to keep everything straight and there's no gap.
And what day are we receiving those?
As early as tomorrow, no later than Thursday.
Okay.
Anything else to be addressed?
I don't believe so, sir.
No, Your
All
Honor.
right, have a safe trip back, Mr. Roth, Mr.
Thank
Pica, and
Your
Mr.
Honor, thanks for your patience. I apologize again for this morning.
Thank you.
Your Honor, may I have a motion on an unrelated matter?
Yes, let me, can you hit the sidebar, please? Greetings.
Your Honor, this is my new colleague at Statewide Prosecution. His name is Drew Fritsch. I just wanted to take the opportunity to introduce you guys.
And Judge, we did meet years ago, when you were new to the bench, you were in Charlotte County.
I did spend some
And
time.
I appeared as a defense attorney in front of you a couple
Okay,
times.
very good.
So, nice to see you again.
Likewise, and welcome to the statewide assignment.
Thank you.
All right,
See you, sir.
very good. There's the plea form. Let me see if you look. I believe we're ready then on the Murphy case to address that next. And that's Mr. Gagoza for the defense, Mr. Ashby for the state.
Mr. Murphy. Mr. Murphy. On the wall.
19 CF 166. And Mr. Murphy present. Welcome back, Mr. Murphy. All right, this is here for a competency hearing, is that correct?
It's actually to determine what to do with it.
All right.
What we should do.
Parties are stipulating to the lack of competency based on most recent report.
Yes, Your Honor.
All right. And the issue will be restorability, and if so, in what manner?
Yes, Your Honor.
All right. Any stipulations that would expedite things? I see we have two expert witnesses here.
Nothing, Judge.
All right. Does either of the expert witnesses need to be called earlier than the other due to professional obligations?
That I'm aware of, Your Honor.
Okay. Dr. McMurray, do you need to get back?
I have an appointment.
Okay. Are we possible to start with Dr. McMurray?
Yes, Your Honor.
Can we call him first then? So let's go ahead with him.
Right this way, Dr. McMurray. This way, sir. Face the clerk, raise your right hand and be sworn in. You can step over this way.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Doctor. Welcome back.
Watch your step, Your
How are things at Lakewood Ranch?
Good.
Okay. I pass it. I used to pass it more often until the pandemic. I don't pass it as much anymore. But, all right. And who will be calling this witness? Mr. Ashby? All right. Let's go ahead.
Good afternoon, Doctor.
Good afternoon.
Can you please state your name for the record?
Donald McMurray,
And how are you employed, sir?
licensed psychologist, state of Florida, private practice.
And you say are you a licensed psychologist?
Correct.
You had an opportunity to conduct a competency evaluation on a person by the name of Jack Murphy.
Yes, I have.
When did that evaluation take place?
I actually evaluated Mr. Murphy twice. First time was in May of 2019, and then the last one was in December of 2020.
Just to start with initially, based on your evaluation of the defendant, what was your determination at the time?
In terms of competency, my opinion is that he is not competent to proceed at this time, or at that time.
And that is based on, it was laid on your report based on the evaluation on December 9th?
Yes.
Have you had an opportunity to review review the other reports related to the defendant's competency or anything mental health?
I've reviewed Dr. Aries' report, and that was in April of 2019, and then I just reviewed Dr. O'Day's report.
And your most recent report on December 9th, 2020, you stated that you do not believe that the defendant was restorable. Is that correct?
That is correct. Well, that was an addendum, yes, but I do not think he is restorable.
Now, questioning on, has he been restored to competency before?
I believe when he came out of the state hospital, they had indicated that he was competent at that time.
And in your report, you cite to both a traumatic brain injury as well as psychological issues.
Correct. He's got a history of both.
Focusing more on the psychological issue, what is his psychological issue?
He has a number of symptoms. He's been diagnosed with psychosis, he's been diagnosed with schizophrenia. He's been diagnosed with, not diagnosed, but he's got symptoms of not being able to stay focused on anything. He's very scattered. As I described in my report, in terms of talking with him, every time you asked him a question, his head would go down, he'd mutter to himself for a matter of time, and then answer in a way that wasn't directly related to the question. And that went on in both evaluations. So he has hallucinations, certainly is delusional, and has pretty poor control of his impulses. What he originally got arrested for was returning to the home he used to live in. Different people live there now, but he would do that over and over and over again. I believe his attorney informed me one time that the other place he goes is to the back of his parking lot. He parks his car there and will sit there for hours and just not do anything. And he does that at a couple different places through town. So he's very perseveration. And he has very limited control over not doing those things because of anxiety, or the anxiety disorder.
Now, those psychological issues that you named and listed, can they and have they been treated in the past with medication?
The only time he's been treated consistently was the 4 months he was in the state hospital, because they can control the medications. Throughout, I think, probably the last 5 years or more, his treatment is inconsistent because he won't always take his medication, and no one has the ability to make him do that.
And if he were to take the medication, would he be able to would he be competent?
I think he's intelligent, and so I think the issue is whether the medications would eliminate his internal distractions, thought processes and emotions. Certainly the professionals at state hospital perceived that did work, that he was on medication there. The problem in the community is there's no way to force him to take medication, period. So he just doesn't do it when he doesn't want to do it, and it prolongs or maintains the symptomatology that he has.
So, with medication, he could be competent, but without it, obviously.
Well, I've never seen him competent, but I'm just, as I said, I'm just related on the state hospital. They thought he was competent. So there's a chance that he could be, but I wouldn't stipulate that yet without seeing him on medication over a period of time. So I could actually observe that.
Now, you gave on your January 2nd of 2021 report, you gave, I believe it was 3 or 2 alternatives to the state hospital for treatment. Is that correct?
Correct.
The first one you suggested was the Center for Independent Living.
The first recommendation had to do with a facility that focuses on people who have mental health issues and traumatic brain injuries. They're usually neurocognitive facilities. And what they have is 24-hour assisted living in essence, and they try to move people toward higher degrees of independence as they comply with medications, as they comply with programmatic issues. Some of the residents move to the level they can go and work part-time. The difficulty is finding the facility, and I think I was suggesting it here. I'm not familiar with this area, so I can't identify those, but I know up in Sarasota, in that area, there's 3 or 4 of those facilities that are highly functional. So the benefit of that is because it's a program, they're able to control medications. They dispense the medications, and so they can do that. And I think that would give him the best opportunity to begin to be able to function more independently. The second recommendation I had to do with the use of the FACT team here in the community, although the FACT team is very difficult to get involved in, and he could still refuse to take his medication. The FACT team can't do anything about that.
So if you were to go to one of these facilities with the independent living facility, Center for Independent Living Facility types, they could dispense the medication for him to address his psychological issues.
That is true.
And you said that also obviously you recommend the FACT team as well. Currently, in your report said he's currently living with his mother, correct?
Correct.
Based on your review of both the defendant and his situation, is it your opinion that she can control and convince him to take his medication on a consistent basis?
Short answer is no. She certainly is very interested in loving and cares about him, but she doesn't have any real control over his behavior or his medication.
I have no further questions, Your Honor.
Cross-examination.
Your responsibility is from the seated position.
Yes.
Hello, Dr. McGuire, how are you?
Very good, thank you.
Okay, so let me make sure I understand this. It's your position he's not restorable, is that correct?
Correct, that's what I said.
And so what will the medication that he's going to get, what will that do if he's not restorable?
Well, there's 2 things. One is when I saw him in December, I had not seen the state hospital psychological report, so I didn't have that information available. So my experience with him is that he has not functioned well in the community for 2 years that I've known him, and it goes back many years before that in terms of collecting history. And in that, he certainly presented significant psychological problems in cognition issues from his head injury. And so it's my opinion that he was not going to be restorable.
No, I understand. I understand it's not restorable. I've been dealing also, I agree with you. But what I'm saying is, if he's not restorable, what's the whole purpose of putting him in a facility or a home, let's say, and giving him medication, what is the medication going to do?
It will reduce his symptomatology like medication does. The facility itself would work with him in terms of daily activities, involvement in the community. Like I said, some of the people in those facilities begin to work part-time, and they can do it because they take medications regularly and the symptoms go down, and they have a 24-hour staff that supervises, so they don't wander off and have difficulties.
Okay, so then, well, what is his condition now? Why can't he, I mean, the way that's been going on, the last time you saw him was December, is that correct? Okay, we're now in June. So, how has he been doing from December to June, since you saw him?
I have no idea.
Have you talked to his mother since then?
No, I haven't. I mean, I can share that as he was sitting back there or standing back there next to me, he was muttering to himself and expressing.
You're talking about Jack or Barbara?
Jack.
Yeah, no, I understand. I'm saying, my issue, my question I have that I don't understand is if he's not restorable, you there's a recommendation that he go to some, let's say a home, and they give him medication. But I'm saying, what do you expect that medication to do? He's not already doing now.
Well, one of the things he's not doing now is taking medication consistently.
Okay, so but in the last 6 months, let's say,
Right.
what are the problems he's been having that he needs medication to help him with?
It would certainly reduce the jumbled thoughts that go on in his head. It would certainly reduce the impulsive, obsessive behaviors he exhibits in terms of returning to his earlier residence, in terms of returning to your office over and over again, or returning to, I think it was a legal building that he would go to also.
Okay, let's say he reduced it, but the condition he's in, let's say without the medication you're talking about, what's the problem? He's functioning, right? He has a driver's license, he's driving a car, right?
Right.
He's not causing any crimes or anything, right?
Well, his symptomatology did lead to the charges he's got now.
Okay.
Yeah, there's no indication that would stop.
I understand it, but what I'm saying is, he hasn't violated any of the conditions of bail. He hasn't gotten arrested on anything. He hasn't caused any ruckus. He hasn't caused any trouble whatsoever. In fact, he's gotten his driver's license straightened out. So he has a driver's license. He's able to drive a car. He lives with his mother. He's not causing any trouble. I mean, why? So I'm saying, when you're saying medication will help him do what? What exactly is it that he needs help mentally right now to do if he's not restorable?
He needs help in getting rid of delusions. He needs help in getting rid of hallucinations. He needs help in terms of getting beyond the fact that he can't keep returning to his prior home.
Okay, let me stop you there. Delusions and hallucinations, right?
Right.
When is the last time what delusions has he been having, and what hallucinations has he been having?
I can't tell you because I haven't talked to him about it, except for like a few minutes today. But I can tell you when I was talking to him before, just like I said, he had no ability to respond to the competency criteria.
All right, but you're talking about in December, you're talking about 7 months ago, basically, right? 6 months ago, right?
I can probably say I'm talking about the last 5 or more years. I don't think his symptomatology has changed greatly in that period of time.
Okay, but he is getting medication to the Lawrence Center now, right?
But I don't know. I mean, if he does, that's fine.
Well, what I'm asking then is, don't you think you would need to do an update to see how's the medication doing from the Lawrence Center? What conditions is he doing? What does his mother say? Can she say she control him? She can't control him. There's no problems with him.
I mean, don't you think you should know all these things before you say, okay, here's what we think should be happening now? I mean, you don't think something more current and evaluation would be necessary?
Those things can all be helpful, there's no question about that. I mean, the more recent information, the clearer the recommendations can be. I'm making my recommendation off the period of time I saw him, the last 2 periods of time I saw him. I can't speak to the last 6 months, although, like I said a moment ago, he certainly was exhibiting some of the same behavior when he was sort of standing next to me back there.
Okay, but let's say everything you're saying is true.
Mhm.
Okay. Can any of those medications you're saying, you're going to a home and taking those medications, is anything, are those medications going to change him for the positive?
Oh, yeah.
How do you know they'll have an effect and they or rather have no effect?
I can base it partly on the fact that the staff at the state hospital said his behavior improved considerably when he was taking medications consistently.
Well,
So,
that's strange that you say that, because when they determined this, when he went to the state hospital and came back, all right, within a week, he was already not, when I was dealing with, he was already not competent.
Objection, Your Honor, counsel testified.
Sustained as the point.
Well, so what I'm saying, he showed appearances of not being competent immediately after being returned here. And we had to go back again and say he's not competent, that's where we had to start all over again.
Objection, counsel testified.
Well, I'm asking you a scenario, Judge. I think I'm trying to ask a factual scenario to see how he evaluates that.
So you're laying that as the predicate to your question?
I'm sorry, Judge?
You're laying that as the basis for
Yeah,
your
that's the
question?
basis of the question.
And objection overruled.
Okay. Let me say it again. You're saying that you think that if he got certain medications, it's going to help him in certain degrees. And, okay, listen. And what are those degrees you think it's going to help him?
I think his emotions would settle down. I think his cognition would improve. I think his obsessive behavior, or persecutory behavior would settle down.
Okay, now what is wrong with his behavior now? Well, let me rephrase it a different way. Why does he need medications to change his behavior now?
Because when I saw him, he was still engaged in some of the behaviors that led to his charges, i.e. going back to his home, i.e. Being obsessive about, driving someplace and sitting for hours and hours and hours, which probably at some point would get him in trouble, because it's unusual behavior. He certainly was experiencing, or certainly having difficulty expressing himself in terms of talking about what he was doing or what the competency criteria were.
Okay, let me stop you there. Okay, first of all, when you dealing with him in December, there's no allegation he had been going back to the house.
No.
No. He had an ankle bracelet on, and there's no indication he'd been violating any of that. All right?
Right.
And the issue I'm bringing up about, you're saying he was in the facility and they restored him. The issue I'm bringing up is, right after he was allegedly restored, we were back in on saying he was not competent.
Correct.
So the point I'm getting at is, they say he's restored a week or so later, he comes back, he's not, we say, look, there's still something wrong here. Now, if we're in that same scenario now, he goes there, that doesn't, and that was, you're saying he was restored. But here you're saying he can't even be restored. It's only going to help him function better in society. Is that correct?
Correct.
But when you're saying he's going to function better in society, you're assuming that as of last December, he was still going back to the house. Is that correct?
I certainly thought he had the potential of doing that, yes.
Right, which would be an indication he just can't stop. But there was no allegation of going back to the house for over a year, or even longer than that. The entire time he's been, I've been representing him, he's never gone back to the house. That's, I don't know, seems forever representing him. So that behavior that you're saying existed did not exist. So, and I'm wondering whether or not you want to do a reevaluation, possibly talk to the mother, say, how's he been doing? We do a new evaluation with him to find out exactly what is he doing. Is he still is he functioning? Is he able to drive a car? Is he causing any trouble or whatever? And, you know, maybe he's sufficient to live at home with the mother.
Objection, or, yes.
Sustained as to form.
Okay, so the issue I'm trying to come up with, and the question I have is, would you agree that maybe it'd be better if you did a more current evaluation?
I suspect, based on the evaluations I've done, if we did another one, it would be similar to the ones I've done before. So I'm not sure. I'm going to be more than happy to see him again. And it may be different. But when I spoke with him and his mother in December, she was also aware that she had no control over his behavior. And she was concerned about it. And she certainly didn't want him to go to a facility. She didn't want him to go to the hospital and all those things like a mother would do. But she certainly struggles with his behavior and the concern that he can get in trouble.
Okay, but my question is, since then, and he's been receiving treatment from the David Lawrence Center, is he doing any better? Your answer is you don't know.
I don't know.
Don't you think you should know that? And I'm not criticizing you, and I'm not knocking you, but I'm saying, don't you think that would be something you might want to consider?
Then I would probably recommend that we do another evaluation and a court hearing within a couple weeks after that, and not 6 months later.
Well, that would be a little more accurate, right?
Well, of course.
All right.
Yeah. Yeah.
Thank you. We're saying the same thing. All right, that's all I have, Judge.
Redirect?
Briefly, Doctor, the defendant is currently experiencing two issues at the same time, the traumatic brain injury as well as the psychosis. Is that correct?
Correct.
The medication obviously would work towards his psychosis and psychological condition.
It would certainly work more through that, yes.
Having both a traumatic brain injury as well as a psychosis, is that an improvement or a detriment to his ability to regain confidence?
What's the detriment? It's more compound. If he only has psychological problems, then it would be easier to treat that with medication and reduce those symptoms. But when you compound it with a head injury, a traumatic brain injury, that affects cognition. And so both issues are there. So it's more complicated.
Addressing at least the psychological issues, does that only leave you with the one issue of the traumatic brain injury?
Well, the psychological issues never go away. The symptoms get reduced. And so it's still there. We know that people take medications for a period of time and then begin to have symptoms anyway. And there's a need to change medication. There's a need to do any number of things. So, I mean, there's no magic answer with it. I mean, you treat it, and my concern is that from a supervision perspective, that he would do better in a facility where people can both control the medication and provide him with skill development. I'm sure the mother does not want that because she loves him very much and wants him at home or close. And I'm probably sure that Mr. Murphy doesn't want that because he'd much rather be in the community than in a facility. But I'm just making that recommendation based on my experience in history with people with traumatic brain injuries and psychological problems. It's a bad mixture.
So, yeah, no further questions.
Anything else?
Sure. Mrs. Murphy, could come on, please.
Before
I don't
asking,
need more, just quick.
okay, for the doctor?
Let him stay for a minute.
Okay.
Judge, I don't have any more questions.
Doctor, can you clarify one thing for the court? In your previous testimony, are you saying that if given a medication regimen that is appropriate and controlled, that it would lead to him simply functioning better in society, or would it actually restore his competency, or both?
I think it would, at a minimum, it would help him function better in society. Whether it would lead to total restoration of competence, I don't know. I really don't.
Okay. Any follow-up from either counsel?
No, Your Honor. No, Your Honor.
Thank you. The witness is excused by both sides.
Yes, Your Honor.
Thank you, doctor. Have a good day, and
Thank
good
you.
luck with everything else. And we have also Dr. Roque Meidenek here, I believe. Greetings, doctor. We're ready to call her.
Yes, sir.
All right.
Dr. Roque.
Please report, raise your right hand.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you, doctor. Please be seated. Welcome back. And thank you for your patience since Dr. Murray had a conflicting appointment.
Of course, Your Honor.
All right, Mr. Ashby.
Thank you. Good afternoon, doctor. Can you please state your name, spell your last name for record?
My name is Stephanie Roque Manalich, spelled ROQUE-MIDONECK.
And how are you employed?
I am a licensed psychologist. I work for a private practice in town
And how long have you been a licensed psychologist?
since 2019.
And have you had an opportunity to evaluate a person named Jack Murphy?
Yes,
And what was the purpose of that evaluation?
to assess for his competency.
And when did that evaluation take place?
It took place in March of this year.
What was your final determination as far as competency is concerned?
My opinion was that he was incompetent at the time.
Based on your evaluation, did you find that what was the issue as far as what was making him incompetent?
During my evaluation, he had a very hard time responding to my questions. Almost every single time I asked him a question, he either would require me to repeat it, or he would mumble to himself and then be able to provide me with an answer. He was also rather paranoid throughout, so he did not want to provide me information about his background, didn't want to speak about his mental health history or his family. So most of the information that I got was from records that were provided to me by his defense attorney and by you.
Now, during the course of the evaluation, were you able to get some information from him as far as to get your complete report?
Yes, I was.
Part of that information was that he was able to understand, at least marginally, or at least to some extent, the purposes of the role of everybody in the court.
Yes,
And he was able to, well, you did mention before that he couldn't understand what the difference between a plea of guilty was or a plea of not guilty was.
he didn't seem to be able to verbalize that to me.
Was he able to verbalize other things though, in relation, for example, under contest?
He did verbalize that he understood no contest, what that was, and he said it. I don't have the phrase in my head, but I know I wrote it down. But it was really difficult for him to explain himself, to even verbalize most of what he was thinking. He was definitely having he told me he was having auditory hallucinations while we were speaking.
Now, as far as the actual trial procedure, he is, from your report, he understood that he had a right to remain silent and had a right to testify.
Yeah, he understood a lot of basic information about the court proceedings.
Now, understanding, of course, he was able to do this, but it is my sense that he had pretty difficult to do this.
Yes, he did.
Now, You mentioned in your report that he has both a traumatic brain injury as well as a schizophrenia and psychosis.
Yes.
In your report, you say that the medication regimen could possibly restore him to competency, could probably restore him to competency, at least as far as the psychosis portion is concerned.
It has a possibility of doing that, yes.
Obviously, nothing can be done about the traumatic brain injury.
Not that I could recommend or that I know of.
But currently, he's facing 2 dueling symptoms, is that fair to say?
Yes.
And alleviating or minimizing one could move the ball closer. Would it be fair to say it would move the ball closer to competency rather than incompetency?
I think that would be the hope, that the medication could help.
You mentioned he has cognitive defects and as well as emotional and behavioral defects. You mentioned that the traumatic brain injury went more to the cognitive defect. Can you explain that?
In terms of, during our conversation, during the evaluation, I would, try to explain certain concepts to him and see if he could, learn and summarize and paraphrase to me. And if it was something he was unfamiliar with, he was not able to do that. He was only really able to do that when it was something he had learned, prior to our evaluation, maybe during competency restoration, was my assumption.
Okay. You mentioned also the emotional and behavioral defects are likely attributable to his schizophrenia. What do you mean by that?
So his emotional instability, so basically his impulsivity, his mood is sort of labile, his persecutory beliefs. In the beginning of our evaluation, he was worried that someone was watching the videos, a video call, that it wasn't a private video call, that it was being watched or monitored by some outside party. He was having, like I said before, auditory hallucinations throughout, and that, would definitely get in the way of his ability to behave appropriately. It would be unpredictable to know if he was going to behave appropriately.
Now, those aspects of things, the emotional and behavioral defects, those could be possibly eliminated or at least controlled to the ability with medication, with the medication regimen.
I would never say eliminated. No one's ever really cured from schizophrenia or any kind of mental illness. But medication typically helps with controlling those symptoms and help making it easier to manage those symptoms.
One more.
Yes.
And you recommended an intensive psychiatric treatment and competency restoration.
Mm-hmm. Yes.
And for the potential to maintain this, if he is restored to competency, for him to maintain that competency, he would have to maintain his medication regimen. Is that fair to say?
Yes.
No further questions.
Mr. Veloza.
Yeah, doctor, unless you understand, are you saying he is potentially restorable or he's not restorable?
I based my opinion off of the information, the records I had been given, and at the state hospital, they had thought that he was restorable after they were able to provide him with consistent treatment. And so my opinion was that based on the fact that he apparently, I did not see him in January, obviously, but apparently he was restored to competency in January. And so if that were the case, then medication should be able to help him to be restorable. That's where I based my opinion.
So you're saying in January 2021, he was restorable to competency?
That's what the report from the state hospital said.
Well, he wasn't in a state hospital in January 2021.
I'm sorry, the evaluation by Dr. Alice, which was the state hospital. Yeah. It was dated January.
That's from that's January.
Well, January 2020, yes.
20. Okay, so we're talking about no,
Right. A year before I saw him.
Okay. And you saw Mr. Murphy in March 2021, right?
Yes.
Okay. Now, just based on what you saw, did you think he's restorable to competency?
I would say he would only be restorable to competency if he was compliant with medication.
If he was what?
Compliant with medication. However, delusional processes are very difficult to treat in general, medication or otherwise. And so there's no way to predict whether or not those delusions will still be there and how much medication will mitigate his symptoms.
Okay, so what you're correct me if I'm wrong, you're saying you don't know if he can be restored to competence.
Essentially.
That's the final conclusion, right? Maybe yes, maybe no, we don't know.
Right.
Okay. Now you heard Dr. McMurray testify, right? Who said
Yes.
more experience with him. He said he's not competent.
Right.
I mean, and he's not restorable. Do you disagree with what Dr. McMurray said?
Not necessarily, no.
Now, what benefit? Okay, so let's just take the thing he's not restorable. Like that. What benefit is it going to be to Jack Ripper society for him to be, let's say, go to a home and live there? Would they give him medication compared to being at home and getting medication?
Well, we have seen just in my history, my experience treating patients that when individuals are compliant with their medication, meaning they're taking it every day as prescribed to them, their symptoms do tend to improve significantly. Whether or not they're fully eliminated, that's different.
And what symptoms are you talking about that Jack Murphy has you think will improve considerably?
The symptoms of psychosis, so the hallucinations, talking to himself, he's responding to hallucinations and delusional beliefs and a lot of the inappropriate thought process or disorganized thought process.
Okay, so the psychosis, do you think it'll go to zero? Do you have no psychosis?
No.
No?
I don't think it'll go to absolute zero, but it should go to a place of being manageable where he can function.
Well, he's able to drive a car and live and function now, isn't he?
When I saw him 3 months ago, I didn't think that, but I don't know. I haven't seen him in 3 months.
Okay, now why do you think he was unable to function in March?
He could barely put together a sentence to speak to me. So
Okay,
that would make it difficult. That would lead me to believe his thought processes were not healthy or organized in any way.
But how is he dealing with life in society?
I don't know. I don't know the answer to that.
Well, wouldn't that be an issue you would want to know as to determine whether somebody needs medication, if they're able to function in society?
Sure. I mean, he had told me that he had struggled to keep jobs, which is one way that we measure someone's ability to function in society. He had said he struggled to maintain employment. And the fact that he continued, before he was arrested or at the time of his arrest, continued to go back to those homes or continued to engage in the same behavior suggests that he has trouble learning from situations where he should not have acted that way, which suggests impulsivity.
Okay, but are you aware that he hasn't gone back to those homes? I mean, back to that house in, 2 years since I've been representing? He hasn't gone back?
No, I wasn't aware.
I'm sorry?
I was not aware.
Okay, would that make a difference if you knew he stopped doing that?
Yes, that would lead me to believe that he learned that he can't do that anymore.
Did you see any indication that he might be violent?
No, we were on a video call. He really didn't have an ability to show that.
Okay, what about, do you think he's a threat to society?
I'm not sure, only because his impulsivity would really, could be unpredictable.
Okay,
But so far, no, he has not been violent toward anybody based on the information I have been given.
How about a threat to himself?
No, well, he wouldn't discuss with me whether or not he'd ever harmed himself or whether or not he was feeling suicidal. So I don't know, actually, based on my assessment.
Okay, are you aware he had an issue with the mental health issue with his driver's license? He straightened that out. He has a driver's license now?
I heard it when Dr. McMurray was testifying.
I mean, that would be something to show that, hey, he's functioning in society to a degree that's acceptable. Would you agree?
Sure.
So when you're talking, you said he has this psychosis. Let's say on a scale from 0, so we can get a number, 0 to 10, where would you see his psychosis is?
Probably about an 8 or a 9 when I saw him.
Okay. If he took medication, where would the degree of psychosis go to, you think? Improve to, let's say.
Possibly, probably down to a 4 or a 3.
Possibly.
I can't predict that.
Right. So all it's, okay, and what's the difference between the psychosis, let's say, in a 9 and a 4, as to somebody function in society?
Their ability to think clearly, their ability to communicate clearly, manage their emotions, make appropriate decisions.
Okay, well, was he able to manage his emotions or not?
I don't know now. 3 months ago, he struggled with me.
Okay, when you evaluate, was he able to manage his emotions?
He required a lot of rapport building, meaning I had to sort of earn his trust during that evaluation. He initially really did not want to participate with me.
No, I understand that, but I'm saying, was he able to manage his emotions? You're saying that it's something that's the medication, if he's in a home and the medication goes, it's going to help him manage his emotions. But you're saying he was able to manage his emotions when you were seeing him, right?
Sure.
Okay, so what else would medication, besides helping manage emotions, which he's already able to manage, what else would it do to help him?
It would help to reduce the auditory hallucinations.
I'm sorry, what?
It would help to reduce the auditory hallucinations.
You know, I think I'm going deaf with these masks. Could you say that one more time?
It would help to reduce the auditory hallucinations.
Okay, now let's reduce the eye.
Auditory.
Oh, auditory cord. Okay, so let's say 0 to 10. Where is that on the scale?
When I saw him, it was about a 10.
All right, if he took medication, where would it go?
It should go down to about a 4 or a 3.
Maybe, yes, no?
Maybe. I can't, everyone's brain is different. I can't predict how medication is going to affect a specific brain.
Okay, so let's say when you evaluated him on a scale of 0 to 10, what was his ability to drive a car?
I don't know.
Well, wouldn't that be something you want to know, if he could drive a car without any problems? Wouldn't that give you an idea of his mental ability?
I should have asked that question. I just not.
Okay. Would the fact that he straightened out his driver's license be an indication to you that he's able to function somewhat in society?
Yes, it would.
What about to go to a store and buy something like Publix? Is he able to do that?
Oh, no. I can't remember, I should say. I can't remember if I asked that question. It would be an indication of somebody who is able to make some basic cognitive decisions.
Right, he was able to do that, right? And he still is able to do that, right?
Yes.
Okay. So overall, you're saying he has some mental health conditions, which I don't dispute, all right?
Mm-hmm.
But overall, he's got mental health conditions, possibly maybe not restorable to competency, but overall, he can properly function in society. He may not be able to function long, so he's got his mother with him or somebody. He can function in society, though, overall, right?
With assistance? Mm-hmm.
Right.
Yes.
And so the medication you're suggesting you get, it'll help him possibly get down, but the reality is, he's already at a level where he can function in society. The medication is going to get him better to mentally deal with his issues or think things through, but he's still able he's still able to accurately do that, right?
Cognitively, yes.
And he was taking medication from David Lawrence Center, right?
He told me at the time he was taking Seroquel, but he also admitted to me that he's never really been consistent with medication except for when he was in the hospital.
Okay. So he was able to tell you medications he's taking and talk to you about his past degree, right?
Very slight, yes.
Right. But that would be an indication that he understands what you're saying and he knows what he's doing. He knows he got to take medication, right?
Yes.
Okay. And so what I'm getting at is, by putting him in a home, let's say, and correct me if I'm wrong, by putting him in a home and getting him to get medication, it may help him, it may not, but even if it doesn't help him, he can still function in society, right?
Yes,
So the only benefit is he'll mentally be more alert or cognizant of his issues, right?
I think he'll have more control over his psychiatric well-being and his own thought processes, his own emotional well-being.
But he still meets the bar right now to be able to function sufficiently in society, right?
For what's currently demanded of him, yes. But if he were to need to get a job, I don't think he would be able to function.
Well, he doesn't get it. He has disability.
That's what I'm saying. If he had to, I don't think he could do that. But based on what's demanded of him currently, sure.
So if he does not go home, as long as he still gets his medication from David Lawrence, and as long as he lives with his mother helps him, he should be fine. Would you agree with that?
As long as he is compliant with his medication.
Sorry?
As long as he is compliant with his medication, meaning he takes it exactly as it is prescribed to him by the psychiatrist, which again, I'm not really sure what that is because he didn't give me that information and I didn't get that information. I wasn't able to get that information anywhere else.
Okay.
If he was compliant, there is a chance he could function.
Okay, so is he compliant or not?
No, he's not compliant.
You don't need to.
I mean, no, I don't know if he's compliant. Based on my experience with him, he couldn't have been compliant at the time I saw him
Okay,
because
that's
he
March.
was very symptomatic.
So it's in the 3 months, has he been compliant?
I don't know. I haven't seen him in 3
Okay.
months.
And even when he was not compliant, he was still functioning to an acceptable level of society, right?
Yeah, sure. Yeah. The very minimum that was required of him.
Okay. Would you agree then that maybe it'd be better to do a more current evaluation to get up to date and try to get a hearing as quickly as possible based on what you and Dr. McMurray think?
Yeah, I think that would be, I'd be happy to see him again if that's what the court would like.
Thank you very much. That's all I have, Judge.
Redirect?
Very clear. Based on your time of defendant, do you think you have the ability to learn, and do you think you have the ability to learn?
I mean, yes, he has the ability to learn because he clearly learned something while he was in competency restoration. My understanding of competency restoration is, it's not just one interaction where they learn the information, there's several interactions. So over a period of time, he probably has the ability to learn. He just could not do that in a very short amount of time with me.
And having him on a medication regimen would, as you stated, reduce him from the 8 and 9s and 10s where he was before to the 3 to 4 levels of his symptoms.
Hopefully, sure.
And would that increase, if he was reduced to a 3 or 4, would that increase or decrease his ability to learn and be restored to competence?
It should increase it.
One of the criteria for competency is his ability to communicate, is that correct?
Yes,
And that would include communicate with the jury if need be, and with his attorney more specifically.
yes.
So having him on a consistent medication regimen would arguably increase that ability to communicate with his attorney and restore him and be moving closer to competency than away from it.
Yes.
How much is demanded of the defendant at this point?
On day to day,
On his day-to-day life?
I'm not really sure. It sounds like, he can do he can go to the store, he can drive around, probably get himself to appointments.
Then you're saying that he lives with his mother?
Yes.
He has a license, but outside of that, does he do much of anything? Do you understand?
I'm not sure. I know he doesn't have a job because of his disability.
But as you stated, if he were to have to get a job, he wouldn't be able to.
He probably wouldn't be able to keep a job. Probably. I can't obviously predict.
And the medication, it is not instead going to eliminate the symptoms.
No.
What is the medication going to do?
Reduce them.
And if the medication reduces the symptoms, does that open him up to, if the reduction in symptoms, does that better enable him to participate in the legal process?
It should.
Would you agree that the ability to function in society is a factor in competence?
To a degree, because part of competency is looking at cognitive functioning. Part of my evaluation is looking at cognitive functioning, and your ability to function in society is tied to one's cognitive functioning.
And again, the medication is going to attack, I said attack, but the medication is going to address the psychosis portion of that, the issue that the defendant is having. Is that fair to say?
Yes.
His cognitive abilities are damaged by his traumatic brain injury.
I would imagine so, yes. But they are also affected by how severe psychotic symptoms, meaning if I could provide an example, would that be okay? If someone was talking to you in your ear consistently, but you were trying to listen, to your honor, for example, you would have a very hard time processing the information he's giving you and be able to participate in a intellectual conversation or even an effective conversation. So my understanding, my assumption is if Mr. Murphy is experiencing those kinds of hallucinations, that would impair his ability to interact effectively or be able to have an effective conversation with somebody, especially one where, having a competency evaluation, for example. So medication should also help cognitive functioning to a degree. It will not fix anything having to do with the traumatic brain injury. That's something totally separate. But it should help his ability to at least pay attention and be engaged to a degree.
Thank you. No further questions.
Anything else for this witness?
No, good.
Thank you. You're free to leave. Have a good
Thank
day,
you, Your
Baxter.
Honor.
Will there be additional evidence from either side? Yeah, let's take a 5-minute break and then we'll come back and finish.
All right, court is recessed, 5 minutes. Mr. Murphy, you can have a seat out back.
But you guys are gonna have a rough day.
Yeah, long day. Our morning.
We're just starting to hit our stride.
We didn't have no bad
What's that, Lisa?
We not at no stride, child. We still got it
We got another 3 hours, Lisa, another 3 hours.
We're just starting to hit stride.
And our big afternoon one, what? He pled. He pled.
You want peanuts? I did bring those down. You want peanuts?
No, I'm good. Lisa might.
You want peanuts, Lisa?
No,
A
thank you.
14-year-old sitting in jail, adult jail for 420 days.
Is that the one they supposed to call as an adult?
I think second.
Right.
He pled out today.
Yeah.
You didn't know about Island Adventure?
That's what we went.
Oh, you didn't go see Blue? Well, when you go there, look for a young man named Al. He might kind of look like me a little bit.
Poor kid.
So you got some paperwork all printed out for us?
Not supposed to. I mean, I think we did it on Friday, that's what you're asking.
Talking about the tolerance.
Yeah. I did it at 1:40.
No, I'm sorry, I'm minutes late.
No, thank you.
That's pretty quick.
Okay, so you know, I didn't even match up.
You didn't do lunch.
Yeah, wait, I mean,
Yeah.
I think that,
Yeah.
Rex is good. Can't be for
So I'm like,
I don't even know what's in the house.
And also, here.
No, yeah.
Yeah, peanuts.
Is that what you're offering? Yeah. Oh, okay, thank you.
I always have food. I got cheese and crackers, and they have a big bar.
Yeah, oh, that's not too.
Oh, got it. It's always stopped.
All right.
That's all I had in my house when I got home from the airport.
Saltines.
Fill up a beer and water.
I got cheese and crackers.
Yeah.
We have an Evans back there?
Yes, we do.
Is he back there now?
Should be. He's there. You want me to put him back there?
That'd be great.
Okay.
To roll home and get my brothers back there.
Oh,
He's back there.
Attorney-client, please.
thank you.
Well, let's see.
I thought I would come down and see what the big boys do.
Oh, good to see you.
Damn thing.
Well, you want to see? Here's what I'm kind of thinking.
You did your own?
Well, I do, while we're doing the calendar call,
Oh, you just read it.
yeah, just write some numbers.
I always hear how busy you guys are, so I wanted to prepare it for my two bills.
Come on, shit right now. But Jeff, what you're doing, he's doing his lunch.
I did.
Why you think Brian can take off so much time? They don't do nothing.
It didn't look like, we don't have like five or six there.
Right.
So what was the young man in custody for 410 days?
Well,
He's in there a long time.
Did he file as an adult?
no, he used someone else's name and date of birth.
Oh, that's not one use his brother's name.
Yeah.
Oh, okay.
He still was locked up?
Well, no, he got out maybe last week.
Oh, okay. Yeah, man, he was in big boy jail for a while.
400 and, he's the one that got the 11-year-old.
I bet you he won't do that no more. Oh, yeah. If one kid, I bet you learned his lesson.
We need an hour today.
Huh?
We need an hour today. I should, an hour tomorrow. Yeah. An hour on Wednesday. From the hours today. We just, I'll get 2 hours today.
What do you think?
We're gonna be late tonight?
Probably a couple hours.
Awesome.
Yeah.
You're finally moving up to juvenile.
1:30, 2:33.
Here's what I'm thinking for jury selection though. Probably do 40.
You trying to try out one?
No,
Can I do 40 in there? I told you that, it's not gonna work.
2 rows of 10 up here.
No, there's no 10 rows of 10.
He told the judge that.
You told the judge 40?
We can do
2
40.
rows of 10.
Right, push those chairs back a little bit.
All right, listen, look at me crack, baby. Look at me crack, baby. We talked about this, you don't do 1 row here, you can't do 2 rows here.
Well, he gave out misinformation.
You cannot do 2 rows.
On the record.
Okay.
Yes, he did.
Oh, God, everybody knows how old you are now, too.
Go ahead, go over there. Full of people.
Is that right?
That was on the record, too.
Hello.
Oh, yeah, you can't support people to squirrel.
That's what it's wrong. It's gonna be a mess.
10, that's 30. We talked about this.
He was with cheesy crackers.
But I agree with some, yeah, she must have been dreaming. If she was just dreaming about stuff at home, just like, man. No, we said 10, 10, and 10. And I said, you want to, we have to put them in the vacuum computer. No, wait, you squeeze it out. Piggies, but got piggies. Well, then why would it did mention something on the TV? You guys are. Not gonna fit 2 rows in.
John, show you.
Hello.
One. Good.
No way you can squeeze the table. Maybe you go into some walls or something, maybe move the wall.
We get everything a little bit closer
Do
to
you
each
need all
other.
4 tables? Do you need all 4 tables?
No, we'll just scoot them all a little bit closer.
All right.
Scoot them all, go in there.
One week with no restriction, and you're already jamming everyone in here.
Put it in there, baby. Let's do it. There's no reason he's 40 anyways. You can't get over that.
I like the number 3 now.
I'm feeling.
Yeah.
Yeah, it's,
The one that was, they were just like 2 screens.
but then, you know, when you're used to something and then it changes, that can be a problem too.
Absolutely, yeah.
You don't get out of 3rd, and you're gonna bring my 3rd down. Quit this shit up.
What's it?
The middle of a paper. It's the middle of the paper, you have me till Tuesday.
7 days. 7 days. 7 days to reevaluate.
Yeah, Mark, you know, you can't mean somebody except with the judge, you can say anything.
Well, when I started, that's how long I was staying for. I said anywhere between 14 days and 3 years. Every 14 days, I reevaluate and see if I'm coming back.
Oh, man. See that guy?
Yep.
And I gave out the wrong information and they ready to leave.
Well, the funny thing is we had a conversation with this last week, we were talking about it. And we agreed on how we're gonna set it up. And then changed it, my Tuesday out and changed it on.
Yeah, this courtroom is not as big as 2A.
No.
Oh. Yeah, I don't know how you're gonna put 2 cents. Yeah, that's a lot.
Who did it before?
Yeah. And what trial? It what trial?
Cebu, Silva.
No.
All rise. Circuit Court is back in session.
All right, welcome back. Let's resume. Please be seated. Counsel, will there be any other evidence on Mr. Murphy's case?
Yeah, I'm gonna call on Mrs. Murphy, Judge.
All right, and Ms. Murphy, please come up.
Ms. Murphy, step right this way, please. This way.
If you face the clerk and raise your right hand and be sworn in.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth? I do.
Please have a seat for the witness box and watch your step.
Hey, welcome back, Ms. Murphy. And Mr. Goza, when you're ready.
Will you state your name, please?
Jimmy Murphy?
And you're Jack Murphy's mother, is that correct?
Yes.
Jack's living with you?
Yes.
So you heard the 2 doctors testify. Do you think Jack is restorable to competency?
Not completely, no.
And you heard the recommendations.
Yes.
What do you think is in the best, tell the court what you think the best interest for Jack is?
Well, I have to agree with both doctors. They were on point. The best thing for Jack, I would like to see him reevaluated. And the suggestion that Dr. Murray mentioned at the ranch, I don't think there's such a thing.
What was that again?
The facility
Uh-huh.
that Dr. Murray recommended, the ranch, isn't a bad idea to see what we can do with Jack. My main concern with Jack is that I've seen him go through a lot of medications, different medications, and been treated more like a guinea pig than trying to help him, which only makes it matter worse. Jack was restored pretty much to meet society, and we went with Dr. Hussey, who actually got him, the hallucinations were gone, the mumbling to himself, he had that gone, but he picked up other things. It was like a trade-off for one behavioral pattern, issue to another. It just changed what he was doing different. But Jack's gonna always have a problem.
Okay, so you'll be happy with it getting, going to the farm in Sarasota and then you circuit evaluated for the
Yes.
That's all I have.
Cross-examination.
No, Your Honor.
Thank you, Ms. Murphy. Please step down. Any additional evidence?
No, Your Honor.
Mr. Ashby, any rebuttal?
No, Your
Uh,
Honor.
What's the position of the parties at this time?
Your Honor, this just stated is based on the doctor's reports, the defendant is incompetent to proceed. State's position is the defendant is restorable. We heard from Dr. McMurray as well as Dr. Manalich. Both of them testified to the dual diagnosis that the defendant has. First being a traumatic brain injury, and the second being a psychosis. Obviously, both doctors agree that nothing can truly be done about the cognitive damage that is done by traumatic brain injury. They do both agree that the psychosis can be addressed with medication and a medication regimen. However, the defendant, by his own choice, has chosen not to take his medication, and she does not take the medication on a consistent basis. Dr. Murray specifically testified that when he was taking his medication consistently was at the state hospital. And at that time, he was restored to competency. Actually, both doctors testified to that when he was restored to competency back in January 2020. What we're here for today is to determine whether he's competent and if he was restorable, and if he's restorable, the process by which that can be done. Dr. McMurray suggested the facility up in, a couple different facilities up in Sarasota that he's familiar with, for the fact team here in Collier. The team that he's familiar with up in Sarasota being the preferable of the two, as they have the ability to issue medication and give a 24-hour consistent regimen for medication. The defendant can be restored to competency. Dr. Manalich testified that where the defendant is right now without being on the medication is at an 8, 9, or 10. And that medication would bring him at least the symptoms that he's experiencing down to the 4. She gave the example of this also being affecting his cognitive ability to learn and understand the legal process, as having someone whisper talk to you in your ear while you're trying to engage in a conversation is distracting. It would affect your ability to hold that intelligent conversation. She described in her report that even from between December of 2020, when the defendant met with Dr. Murray, to March of 2021, the defendant, that even in that short time frame, improved significantly. With Dr. Murray, he was unable to know what his attorney did, what the prosecutor's role was, what the judge's role was. He had no idea in any way, shape, or form the understanding of the legal process. With Dr. Manalich, he was able not only to understand what his attorney's role is, what the prosecutor's role, what the judge's role was he was also able to articulate that what a no contest plea was, what competency is and is not. He was able to articulate it. Understanding it was with some difficulty and it took some prodding and pulling to get it out of him, but he was able to do that. That can be addressed with the medication regimen that would reduce the cognitive ability and allow him to more easily be able to communicate and participate within the legal process. The state's position the defendant is restorable. Dr. Manalich testified the defendant does have the ability to learn, does have the ability to continue to improve upon his current situation, but he would need a medication regimen to do so. As he is right now, unmedicated, he is, as both doctors testified, he is functioning in society for what he is asked of to do, which is essentially stay at home with his mother and on occasion go and pick up his medication. There's not a lot of demand, there's not a lot that's being demanded of him. But he's able to function in that role. Giving him the medication would allow him to also function in this arena where he's currently facing charges, one of which being a firearms charge, and so that the justice process can continue and be eventually concluded. So for those reasons, Your Honor, we ask that you find the defendant is restorable, and take the recommendation of Dr. Murray and having him sent to the Center for Independent Living, so that gives constant restoration to begin.
Are you interpreting the testimony to be that he meets the criteria for involuntary civil commitment for restoration?
I don't believe we can send him to the DCF State Hospital. I don't believe that we could do that. He doesn't meet the criteria. As both doctors testified, he's not a danger to himself. He's not currently a danger to others. He's not exhibited any violent tendency. Not both doctors did say that he does have auditory hallucinations, and he has poor impulse control, which is a concern. However, by himself, without anything else corroborating, it doesn't. Based on their reports and their evaluations, the state cannot stand here and make a legal argument saying that the defendant meets criteria.
Okay. Thank you, Mr. Goza.
I really don't understand why the state's argument. Everybody's always restorable, there's no problem, everything's smooth. Dr. McMurray said that Jack Murphy is not competent and not restorable. There's no questions about it. Mrs. Manalich, Dr. Manalich has basically, she doesn't dispute what Dr. McMurray says, that he's not restorable. So all of a sudden, somehow out of that, the state comes back and says, well, the state says he's restorable. There's no evidence of that. And the evidence what they were talking about is that he can function at a level where he can drive a car, he can basically do certain things in society, he can't work, but he's not a threat to himself, he's not violent, he's not violating any court orders, he's not going back to that house that he was doing over and over and over again, but he's functioning. So the question is, well, if he's functioning, when are you going to give more medication? Well, the argument is, well, he'll function better, maybe. It's all speculative. Okay, so fine then. The evidence in front of the court is that he's not restorable. There's evidence in front of the court that he can go to this place in Sarasota, and that Mrs. Murphy says, I know it, and I think that's the place where he should go. She called it the farm. I don't know if it's the Center for Independent Living, but whatever. I mean, but I think that's the same thing. The doctors say that. Mrs. Murphy says that. There's no evidence he's restorable. They have to do an evaluation anyway to see what he needs for help over there, to see what they think and how long they want to keep him and what they want to do.
So you're saying he would go there voluntarily?
Yeah, I could put Mrs. Murphy back on. She's saying that she will drive him, once we get a court order, there's a place, she'll drive him over there and get him, because she thinks she's always thought that was a pretty good place for him for quite a while. if it need be. But she had been talking to Dr. McMurray about this for, I think for over a year, since we had the last evaluation done, so. But I think the question, Judge, is, we're gonna keep coming back, restorable, not restorable. The evidence for her court is not restorable. Let's just move this case on. You can order that he go to the Center for Independent Living, or the farm is that the farm? Yeah, that's right, Judy? The farm is, okay. Yeah, you can go there, let him do the evaluation, but I think the court should say he's not restorable. And let's move on with this case. And let him go to get the medication and see what, let them keep him there and whatever, and see, I don't know. I'm not even sure how it works at that point, how long they're gonna say they're gonna keep him there. They're not gonna keep him forever. But the problem the whole issue though is he's functioning. They're just saying he can function better, but it doesn't mean it's not sufficient for the law. Under the law, he is functioning, okay, he's driving a car, he's not violating any law. So what more do they want? He's not working because he's got a mental disability. He can't get a job. So I just don't see a benefit to state or him just to keep dragging this thing on. If they were saying, no, he can't function, whatever, then that's different.
Well, the state hospital said they were able to restore him.
Well, yeah, state hospitals always say that. And then the problem with the state hospital, Judge, as soon as they send him back there, he's filing another motion for a competency issue. So, but we don't have the evidence in front of the court is not restorable. So, because the state hospital, this is a year ago, don't forget, we dealt with the state hospital. So now we're dealing with what's the evidence in front of the court? Two psychologists say he's not restorable. So why would the court say he's restorable?
So your request is that he be found incompetent and not restorable.
Not restorable.
And what further order would be entered?
And then order him to go to the Center for Independent Living.
Anything else?
That's all I have, Judge.
Mr. Ashby?
I would state disagree that the evidence before that is not restorable. The evidence report from the doctors is that if he is put on a medication regimen, an assisted medication regimen, he is in fact restorable. In fact, last time he was put on a medication regimen, an assisted medication regimen, and was compliant with medication, he was restored to competency. The problem is when he is not on medication, when he is not on a medication regimen, and he's not consistent and compliant with his medication, he devolves into incompetence. What we have here, two doctors who both testify that if the defendant is compliant with his medication, he can be restored to competency. He can go from as Dr. Manalich testified, the 8, 9, and 10s as far as the symptomatic that he's experiencing, to a 3 or 4, which will improve his cognitive ability and his restoration and his competency and being allowed him to be restored. Dr. McMurray testified that the medication would reduce his symptoms and improve his abilities. In fact, testifying that the medication had a positive effect on his symptoms, and that is based on past experience, namely the state hospitals, where he was again on a consistent medication regimen and he was compliant with his medication. It is only when the defendant is not compliant with the medication, not on medication regimen, not taking his medication, that he's incompetent. But once he is taking his medication, he is competent and he can stand trial for the charge to which he's facing. That is not someone who's not restorable. That's someone who's incompetent, agreed. But it does not mean he is not restorable. He's currently incompetent.
It seemed to me, Mr. Ashby, that their testimony, their opinions were more guarded than what you seem to be arguing, that it was so straightforward. They seem to have a lot of reservations because of the dual component of his problem, both the cognitive traumatic brain injury as well as the psychological issues. What leads you to be so confident that they believe he can be so fully restored despite the dual problem?
And I have a question on both of that. He's currently facing the dual diagnosis. the traumatic injury as well as the psychosis. Having them together does make a problem. It does make it more difficult, it does make it more challenging to restore competency. And both doctors did testify to that. The state's not shying away from that. However, addressing the psychosis aspect of it can at least bring him to the competency as evidenced by as both doctors testified, the past performance when he was on a consistent and compliant medication regimen. That, the best predictor of the future is the past, and in the past, that has worked. Whenever the defendant gets off of the medication, is not compliant with the medication, he devolves into incompetence. Dr. McMurray testified that he had not been compliant with medication based on his review of the records for approximately 5 years. This is where, and that has led to his legal troubles in the case which we're presenting here today. If he's consistent on his medication, compliant with his medication, we one, have a person that can stand trial and stand for the charges which he's facing, but also a person who's not being returned back before his court on other charges.
Okay, thank you. Anything else, Mr.
I just want to add one point. I disagree on what Mr. Ashley said about when the state hospital found him competent and sent him back there, he became not competent. There was no evidence and no testimony. The reason he became incompetent because he wasn't taking medication. That's not true at all. He was going to David Lawrence Center, he was taking the medication, and he still became incompetent. So, contrary to the state's argument, there's never been any evidence presented at all that once he was determined incompetent, he went back to incompetent because he wasn't taking medication. That's not true.
I'll go ahead and set this for a further competency review. In the meantime, and issue a written order. I do think it's a bit complex, as both doctors recognized. So I need to weigh the competing requests here and square that with the testimony that I've taken substantial notes from. It is a lengthy history and a complex situation, but let me go ahead and set the competency review. You'll have the order in advance of that, and then depending on the order, we can decide what, if anything, should be scheduled. And I think next we'll be addressing, let me see, yeah.
Judge Manalich's office.
Hello, Melissa. On the Murphy case, I need to set a further competency review. I think we can do that approximately 30 days out where both counsel are available. I'm going to need to do a written order prior to that hearing date. But for the actual review, I think we can just set it as a status for 15 minutes because the order will be entered before then. So I'm looking about 30 to 40 days out and see if counsel are available.
Okay, and this would just be by,
I think we probably should have everyone in person if we can.
okay.
So I wanted to take a look and then we'll ask counsel their availability. While you're doing that, because it's, I think, going to be very brief, Mr. Lester, has Mr. Ermacor indicated whether he was going to be present in person?
By Zoom.
Okay, so we may have him in just about 5 minutes or so. Then I've got Evans to be followed by Rios. Okay.
About Monday, July 26th at 1:30.
And please make a note, Melissa, that I need to submit the written order in advance of that hearing.
Okay.
So let's see, counsel, how does that look?
I don't have anything in it. I might.
Okay, right now it looks okay, Mr. Ashby? All right, and Ms. Murphy can bring back Mr. Murphy then?
Yes, you are.
All right, very good. Anything else for today?
Thank you very much.
All right, good to see you again. Goodbye. And Melissa will confirm that.
Okay.
All right. I don't see Mr. Ermacora, but I have everybody here for Evans and the court reporter, so let's go ahead and start with that. State v. Evans, 19 CF 14, case management as well as a Nelson hearing. Greetings. Before we start, Ms. Fuentes, on the Dundas case, a plea colloquy was done. It was set for October for imposition of sentence.
Thank you.
So that was on our calendar call.
Thank you.
All right, Mr. Nagel, Mr. Darrow, Ms. Beard. For the defense, Mr. Evans is present. Welcome back, Mr. Evans. Please be seated. Greetings. And for the state, Ms. Brown.
Yes, Your Honor, and Mr. Ashby.
All right, Mr. Ashby. Now, for clarification for the future, will Ms. Cunningham remain as counsel, or will it be the two of you?
It'll be the two of us.
All right, very well. And this is 19 CF 14, and this is here for two reasons today. One, and I think in order that we should take them, would be, I assume the defense, well, would the defense like to hear the Nelson hearing request first, or give an update on case management followed by the Nelson hearing request?
I guess let's do the Nelson request first.
All right. Now, let me just mention that I'm going to want to consider whatever Mr. Evans wishes to present in that regard, and we'll probably take that under advisement, do a written order promptly within the next 10 days or so. So if you want to address the case management, since I'm not going to make a final decision on Mr. Evans' request and want to think about it and do an order on that, do you want to do the case management first, just for an update? And then I'm understanding that Mr. Evans is seeking to have new counsel appointed. Now, Mr. Evans, is that still your request at this time?
Your Honor, I'd like to request a continuance on the Nelson hearing.
Okay, you want to talk further with your counsel about that?
Yes, Your Honor.
All right, that's fine, and we can just address case management today. Do you want me to set your Nelson hearing request for a date in the future, or do you want to communicate with the court if you desire to have another date set?
You can do it that way.
So the second way? All right, good. I would encourage you to speak to your lawyers.
Judge, often when there's a Nelson request, there's a souring of the relationship. That hasn't happened. We're still talking to him. We still get along. And there's still.
So I understand, especially in a case with this much at stake, Mr. Evans, that occasionally there will be tensions that may arise in the lawyer-client relationship. That's not unusual, but I would encourage you to speak to all of your counsel and see if that can be remedied. They are well known to the court. They're well established in the community. They have a lot of experience, but I will entertain your request in the future if you have one. But I'll grant your request to defer this, and let me know, as you did with the Nelson hearing, if you wish to renew it. Otherwise, I'll leave it as is for the time being.
Thank you, Your Honor.
All right, and let's then proceed to case management.
Judge, as far as case management goes, we do have additional depositions set up. We have depositions set now. There are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 set in August. And then we have the medical examiner set at the end of September. That is going to get us to the majority of just your general law enforcement officers, and we're going to need, then we are going to need to set the lead investigators, and we've had a horrible time, and I think the state can concede that, with getting any of the civilian, the more relevant civilian witnesses. When we've set them, we've either not been able to get them under subpoena, or I don't know if we've ever gotten any of the important ones under subpoena, and they're out of state. So that may prove difficult in the long run, but we've got to keep trying. As far as, I know there was a cell phone issue. I have gone over and reviewed part of the cell phones. I've been trying to set another appointment to get over there, because just my schedule hasn't worked with the NPD representative. It's my understanding that there's another cell phone that I may be able to review, but we're still waiting on a warrant return on that, or the state, I don't think we've submitted it yet. So my thought was, if we can put it out, I don't want to go, we're getting to the point of where we can really start seeing things moving. But as of right now, we have definitely set at least till the end of September.
Now, do you think with the pandemic restrictions easing, that will facilitate things in terms of the discovery process?
I think it will make depositions easier of the people we can find. I don't know, and maybe the state knows more than I do, but there's 3 civilian witnesses that are very important in the case. We haven't been able to get, I don't believe we can get them under subpoena for that, though. It's always gone unserved. And I know that, I know I'm not faulting the state on that. These are transient people that are bouncing all over the country.
Do you need any court involvement at this point?
I could ask you to order them to get me whatever address they got, but they're doing that anyway. So I certainly don't think that, I don't think that's necessary.
So it's not a matter of an order to show cause on the witnesses?
I don't think it's any ill or even negligent act upon the state. I think these people was very hard to put a finger on.
Additional motion activity contemplated at this time?
Not yet. There will probably be some motions, but we want to finish we want to get everybody, we'd like to talk to them first, obviously, but that may not be something. I don't know if the state has a feeling as to whether they're ever going to be able to put a finger on them.
Your Honor, I believe I know the civilians that Mr. Darrow is talking about. As we get updated addresses, we provide those. I don't know whether or not how that's going to look moving forward. We have had difficulty ourselves since they gave their initial statements to the police, having contact with them.
As far as the remaining discovery, when do you anticipate that might be concluded?
Probably will need another month or two once we finish these.
We need to, until we get all of the cell phone information, we're in that same boat that we were before with the cell phones. There were downloads that both Mr. Darrow and Mr. Nagel were reviewing of Mr. Axley, the son of the decedent. And we were, the last time we were in court, we were informed by the state that they were getting a warrant request for Mr. Knut's, or however you pronounce his last name, his cell phone, and we're still waiting on that.
Now I have a note here.
I need to go through both of those, talk with the state, see. I can't tell the court at this point with what I've seen whether I actually need to have any of that, which was the state's argument before, and understanding that I need to look at it, digest it, and complete looking at it. Then as far as Mr. Knut's phone, I'm assuming they would be willing to follow the same procedure once they get it, and any relevance on there or not.
Well, that had been the subject of a prior motion hearing, but my recollection is that those issues were to some extent resolved.
We essentially went through the motion and are working with the state on those particular issues. We may never need court involvement. We may.
That evidence, however, has been preserved. It was a question of the access.
The phone that the warrant is for is in police possession. It's not going to go anywhere.
So there's no concern of any evidence being lost. It's simply the other issues that were described. Okay. Now, I note here from the case manager that as of it appears in May, there was correspondence to the court, which I have not reviewed, as I don't in most of these cases, that when it comes in, it's an ex-party communication from Ryan Axley, and that should have been then filed in the court file with copies to the parties. So I don't know if you received that. I don't know what it says.
We have it.
You have it. So to the extent it might affect, issues concerning discovery, I just wanted to make sure that both sides have been provided that.
I don't believe, Your Honor, that we got a copy of it. We were informed kind of through the grapevine that there was a letter in the court file and we got it there. But I don't believe that we ever got a copy of the letter.
Well, typically, in all cases, the court, when it receives ex-party contact like that, does not review the correspondence, but alerts the parties and provides a copy of whatever was submitted. So I didn't know if that touched upon any of your concerns, including location of any such individual.
I believe we've already.
We
deposed him.
Okay.
And I don't think it has anything to do with that.
But if you do not have a copy, certainly that should be obtained.
It's in the court.
All right.
Yeah, we got it.
From the outset, I have been in this type of case, I've been discussing with the defense. The defense has indicated that mitigation efforts were begun, but because of the pandemic, they were hampered. Do you foresee, Ms. Beard, progress on that now that things are loosening up?
Yes, it is. Yes, our mitigation people are back on the scene, we can contact and going forward with that. So finally things are moving along the road.
And defense counsel, as always, as is your practice, you'll, especially in this type of case, will endeavor to keep Mr. Evans apprised as things develop then.
Yes, and Judge, another, I mean, part of the problem is throughout this, and the reason I think part of the reason for the health request is we've only been able to video visits with him until recently. They serve about 60 to 70% of the purpose of a live visit, but we have been able to, and Mr. Nagel and I went over to see him the week before last. And
So
I think
that
the
is
live
no longer
visit's
an obstacle?
not an obstacle anymore, and it's
Okay, and
much better deal.
if it were to become an obstacle for any reason, again, you certainly can address it to the court
Okay.
in this type of case, because I would, obviously, with all due deference to the sheriff's department, given the importance of this case, I would certainly, if there were an issue that was impeding the preparation of the case, I would be willing to address it with sheriff's officials.
Thank you, Judge. As of right now, we're good. The video visits are very awkward.
Are there any expert issues that need to be discussed at this time from either side? Are there still ongoing disclosures still pending from the state?
Your Honor, there are. Ms. Cunningham, I believe, was sending to Your Honor today a search warrant for Mr. Canute's phone. She apologizes for the delay, but that is being sent to the court for approval. As well as Mr. Evans' phone, that previously was a search warrant approved for the search of his phone. There have been advances in technology that we believe will allow us into the phone now. The previous search warrant was granted, but we were not able to get into the phone, so a new search warrant is coming for that as well.
For which individual's phone?
Mr. Evans' phone and Mr. Canute's phone.
Now, does the defense anticipate addressing anything related to those comments?
I mean, if we just, obviously, they have a warrant for the phone, so I think they can do that. We just need to see whatever they get. And obviously, I don't mind, I do not have any problem with going over to the NPD and looking at it first before we decide that we actually need it.
Well, in my understanding, Your Honor, and I obviously will confirm because I left for a time, Mr. Canute's phone will have to be inspected because he's not the defendant. However, should we be able to conduct a forensic download of the defendant's phone, assuming there is no illicit material on it that would prohibit disclosure? My understanding was we were disclosing defendant's phone downloads to their counsel. So unless that rule has changed or there is something illegal on his phone.
I think they would give us a copy of his download, assuming that we have the proper, and there's ways to do it, to attach the program. These are Cellbrite downloads is what we're dealing with. It's proprietary software. Actually, our office has it, but in all the cases I've worked on with it, they'll actually attach it to the program, so you can open it right there. That's what I've looked at, looking at Mr. Axley's phone through. I'm sure that's the way they're going to do the others. It's a constantly changing field with that. It's even since I've been working on the last case with these, what they can get into and how it displays is always a moving target. Ultimately, if there were things in there that we do want to use, I have an expert that I use in association with those, the Tallahassee. But again, until I go through everything myself, and while I'm not an expert, I have dealt with a lot of these, I should be able to see what's there and whether there's anything we really need. If we do need something, I'll talk to the state. If they don't agree, we'll follow motion.
Any medical examiner or FDLE evidence issues that you anticipate?
Not at this time.
We have the medical examiner set for deposition already.
Very well.
There were in the evidence that we discovered that statements of several of the lay witnesses that are throughout the state. So we need to review that as well, unless the state is able to get those statements and forward them to us. We discovered after we did a deposition of one of the evidence people that there were several statements. I think that I discussed with Your Honor before that there were several lay witnesses about the state. And my first understanding of them that they were just sort of witnesses that handed videos or something over. But they were also, then we discovered with the evidence list that there are statements that they made that were put into evidence that have not been disclosed. So we either have to go and get copies of them ourselves or request from the state, get the copies of the statements. I don't know if they're digital or if they're handwritten, I just don't know.
And I did receive an email this morning, Your Honor, from one of my detectives that there's a number of audio and video statements that have now been transcribed. Those transcripts are being sent to me for the next couple of days, and those will be disclosed. And I have those item numbers, so I can let you know what ones those are.
Great, thank you.
Other concerns at this time?
That's a pretty good Photoshop of where we're at.
And we've addressed there today with Mr. Evans indicating that he wishes to continue his Nelson hearing request, so that kind of addresses any conflict issues in the representation. But related closely to that, I assume there's no competency issues at this time.
No competency issues at this time, and we don't have any conflict with him right now.
I understand that things are hopefully going to become a little more doable now in terms of the motions and the discovery as the pandemic restrictions are eased. I would like, however, given our discussion today, probably to return in 60 days just to monitor that everything and your jail access to Mr. Evans and everything is going smoothly as we are anticipating.
That is what I was going to ask for, Judge. I think that's an appropriate time, and then we should have just in case there's any problems that we could.
If we complete the schedule that you anticipate with the depositions and other discovery efforts at the conclusion of that time frame, which is what, October or November?
End of September.
Okay. At that point, what percentage of the known discovery will we have completed at that
We'll
point?
have done 80 to 90% at that point. All that will be left were those the civilians. There's some people in Georgia, and there are the lead detectives. For strategic reasons, we always like to do the lead detectives back that last.
When does the defense and then also the state think that we might be able to start thinking about an appropriate trial cycle? I'm assuming in 2022.
I would think early 2022.
We would hope so. It really depends on what happens with the downloads and what happens with the transcripts that we receive from the state and any other witness statements.
So are we thinking that before the end of this calendar year, we would have a conversation about a trial cycle being set properly in advance in 2022?
Yes.
I would think so, yeah.
Yeah, I mean, we've made a lot of progress.
The state have any additional comments?
We do not.
Then let me go ahead and see if we can set from court here 60 days from now, the next case management.
And Judge, we do have that. The letter is in showcase and I reviewed it right now. I've seen that before.
Judge Manalich's office.
Hello, Melissa. We need another case management date on the Evans case. Approximately 60 days out, please, and we'll check with both sides.
Okay.
I would assume today was about 20 to 30 minutes is what we would want to reserve. It would be at that time, Mr. Evans, that, well, we could always set it specially, but that's also an opportunity if for whatever reason you wish to renew your Nelson hearing request, it can be addressed. Hopefully that won't be necessary, but I appreciate your patience and your willingness to continue to work with your counsel.
August 30th at 3:30.
I think I'm going to need to avoid that day, Melissa. You and I haven't talked about it yet, but I think I may have a conflict. So let's look at something. It can be a little after that, but that's okay if we need to. Ms. Beardy may have a conflict.
Yes, that is right around the date of the Life Death Conference that we all need to attend.
Right.
And after that, I believe that I am going to be in the state for a week or so.
So we're either looking prior to that date or in mid-September.
That would be fine.
So Melissa, we could do it prior to that date.
I was looking prior to that date, but that's why I was back into August 30th, so it's gonna have to be after.
All right, that's fine.
But, so, later, like, September 2nd, would that not work?
I think Ms. Beard is out now. Can we proceed, can we proceed with Mr. Mayo and Mr. Darrow?
I don't mind that.
All right, so, what day were you looking at, Melissa?
September 2nd at 3:30.
Let's check with the parties on that. I don't know if that's around Labor Day, but
That would be fine.
What day of the week is that?
Thursday.
That's fine.
so that appears, Melissa, it's a Thursday, is that correct?
Yes,
And the date and time again?
September 2nd at 3:30.
Anything else for today?
I don't believe so.
All right, thank you. And we have the court date set. All right, I do see Mr. Ermacora connected, and of the remaining matters, let me just check on what may be the briefer of the two. I suspect that Mr. Lester's case may be the shorter of the two. It's a status update. Mr. Ermacora, can you hear us?
Yes, Judge, and I agree. We don't have you ordered another assessment. We don't have a report from the doctor yet, and we can't really do anything without that report.
Right. I know he
I
was.
think the state agrees.
It was Dr. McMurray, and I think he was appointed and was going to be meeting. Melissa, are you still there?
I am.
Do we have any information on whether Dr. McMurray, when he thought he might be able to have a report?
I did not, I was not able to send that email out. He was just appointed the end of May.
Okay. When were we last together, Mr. McCora? It's with Ms. Brown, I'm assuming.
Yes.
All right.
When was the last court date?
Right. When did, because
It was around the same time. It was towards the end of May.
so, all right, so there was no delay. It appears that we appointed Dr. McMurray shortly. I'm not sure why we set this date so quickly, just to make sure that he was going to be doing the evaluation, or I'm not sure why it would have been set so quickly. But in any,
I don't recall either, Judge.
all right, but
mean-
I just wanted to make sure it was progressing. Is Mr. Lester available?
Bring him out.
All right, so if we can have Mr. Lester join us briefly. Thank you, Ms. Stevens. I think this will be the briefer of the two, so let me go ahead and address Mr. Lester's cases. There are a number of them. I'll just reference 18 CS 123, 122, 152, 917, 1241, 250, 273, 281, 299, 828. Mr. Ermacora remotely, Ms. Brown in person, awaiting Mr. Lester. I'll call you back if necessary, Melissa.
Okay.
Five 12. Yeah, it looks like we were last in court on May the 12th.
Thank you. And I see the appointment order here dated May 20.
May 20th or 21st it was filed.
All right, Mr. Lester is back. Welcome back, Mr. Lester. How you doing today? Hanging in there? Okay. This was a status check. I assume Dr. McMurray hasn't met with you yet?
30 minutes ago.
Well, okay, because he was here on another case, so it was you he was going to see. He did say he had a case to see, so apparently he met with you?
Yeah, he seen me well, not like 30 minutes ago, like 2 hours ago.
Very good. Very good. So we're making progress. So now we just need time for the doctor to form his opinion and report. So at least things are moving along. What I show is it looks like we were last in court around, you said, Mr. Ermacora, May 12th. Is that about when you said? And I issued.
That's what the docket says.
Okay, I appointed Dr. McMurray on May 20, so we're moving along, and he did meet with Mr. Lester today. So this is obviously very important before we decide the direction this case should go. Typically, the doctor does his report within 30 days. So we need to have a competency status review, I think about that time frame out. Mr. Makora, any comments in relation to any of this?
No, Judge, I agree with that.
Ms. Brown, any comments from the state?
No, Your Honor, I'm in agreement with, Your Honor, proposal, how we report.
Thank you for your cooperation at the interview, Mr. Lester.
Hey, I want to ask you a question.
Yes, sir.
What are you gonna do about my medication?
Well, that's something that I want to see the report from Dr. McMurray. And then I have a limited ability to affect that depending on what the report says, because the jail is charged as a separate branch of government with administering the jail, including the medical treatment and medications. But to the extent it affects the case, I may have some say in that.
They said they can't touch my medication because something by law in the state hospital put me on it, and they can't change it, but it's messing me up though, man.
Okay.
And that's why I've been refusing it. And I need something else.
So you feel it's affecting your health and your thought processes, Mr. Lester?
Yeah, they got me on 1,500 milligrams of Depakote, and it's making my mouth dry, and it's giving me shakes. So the last 2 months, it's a mood stabilizer, but for the last 2 months, I ain't been taking it since I've been back from state hospital because it's messing me up, and I need some bad.
Is there some medication that they're not giving you that you were being prescribed at the state hospital?
No, they giving me everything, but I'm refusing the Depakote because it's messing me up.
Okay, so what?
And I need, it's a mood stabilizer, and I need a mood stabilizer.
Mr. Ermacora, perhaps you can, I don't know if you want to reach out to Dr. McMurray and see if he has a comment in regard to that concern, as it might affect competency or the legal proceedings. And let me know if there's any role for the court to get involved in on that. I would be concerned if it's something that is going to affect Mr. Lester's ability to participate in these proceedings.
I can do that, Judge. I'll get a hold of the doctor and speak with him. And then if we need to get court's assistance, I'll get a hold of your assistant.
All right. Any comments from the state?
No, not.
Let me go ahead and I'll wait to hear from Mr. Ermacora on that if he talks to Dr. McMurray. And let me go ahead, so I can address that sooner than the court date, Mr. Ermacora, if Dr. McMurray has some comment on that needs follow-up and an action by the court. I just don't want to lose the progress we've made. Mr. Lester, after his lengthy stay at the state hospital, seemed to come back in a good mental condition overall to participate in these proceedings, and I would like to preserve that if there's something for the court to address on that. Melissa, if you're available, I needed to set the competency status review with Dr. McMurray. He just met with Mr. Lester, and typically he will do his report within 30 days. So I would like to set a competency status review here from court. Also, it's possible that Mr. Ermacora may be asking for a motion hearing prior to that related to Mr. Lester's medications, depending on what Dr. McMurray comments.
Okay, now would this be a Zoom status or?
I think for purposes of the status, yes, Mr. Ermacora can appear remotely since he is out of county. The state can either appear remotely or in person. We would have Mr. Lester in person.
Oh, okay, then let me find a different date.
So I think for that date, it would just be on the status review for 15 minutes, depending on Dr. McMurray's report, how the parties want to go. Again, Mr. Ermacora may be trying to set a motion before then on other issues, depending on what he finds. And while she's looking for that, Mr. Ermacora, anything else beyond that?
No, Judge.
Ms. Brown, anything else?
No, Your Honor.
How about Tuesday, July 20th at 1:30?
Okay, that's about the right time frame. Both sides available, remote or in person?
At 1:30
Correct.
on the 20th of July?
Right.
Yes, sure.
Mr. Amakora?
Yes, Judge, I'm available.
All right, and if there's a motion for me to address regarding Mr. Lester's concerns in the interim, please act accordingly. All right, thank you, Mr. Lester.
Okay, I want to say one thing. When I seen that doctor today, he told me that he was gonna, cause I told him that by law, they can't change my medication, and that's what the jail been telling me, and he said that he's been a doctor for years, and he said he never heard of no such thing like that, so he said he's gonna talk to these people.
Okay, well, that's why I said I'm going to have Mr. Amakora follow up with Dr. McMurray, and if there's something that is properly within my role to address that affects your ability to participate in this case and be competent, I'll certainly address it. All right, thank you, Mr. Lester. All right, Melissa, that is confirmed.
Okay.
All right, thank you, Mr. Amakora. Goodbye.
Thank you, Judge. Have a good day.
All right, last but not least, State v. Rios. And that's Mr. Ashby and Ms. Stevens.
And you're a couple minutes to start.
Yes. Go right ahead. There are two cases, 19 CF 473 and 633. This is here, I believe, on the state's motion, which I believe was filed back in January to revoke defendant's bond. I've been informed by the defense, if I recall correctly, that Ms. Rios recently gave birth and is attending to that situation. Was she going to be connected remotely today, Ms. Stevens?
Yes, Your Honor, she's actually already signed on to the meeting, like, here,
Okay.
I
And
have to
we're-
let her know that we're signing on.
All right, and we're going to try to have her on this screen here that's being installed, all right?
Your Honor, this is for the state witnesses. I don't know what screen that is.
And Ms. Stevens, were you able to make any arrangements for that?
I'm sorry?
Were you able to make any arrangements for Ms. Rios's remote appearance?
Yes, I actually sent everybody a zip code. You know, I emailed it to the state and to court administration. Only first thing this morning that I learned from court admin, once they got this equipment down, that they don't provide a laptop. I don't have a way to hook into it. I don't know if the state equipment can, but if the state can get out to the internet and they can log on Zoom, then it'll go right through. As long as they log into the meeting, it'll come right to the monitor and we can see everybody.
All right, let's see if we can.
So,
So the state has witnesses remotely, is that correct?
Yes, Your Honor, and we have our own Zoom code for that witness. We're not gonna be able to pull up defensive Zoom code because we only have the one laptop. So I'm not sure what the judge wants to do. I'll ask you that.
I mean, if they have a Zoom code for Ms. Rio, but then have her hang up and dial the state Zoom code, if that's not a problem, and then they should all be able to share at the same time.
Is that a concern for the state to do it in that manner?
I mean, Ms. Rios has appeared, she's had other hearings on her child support case, which is, I want to say it's 19 CR 2225, where her and the biological father, who is, you know, connected to this case, have appeared for court meetings with or without a contact order. So, I mean, they're in Texas, she's here in Lehigh Acres, and myself and Dave are here in person. I don't see why that would cause an issue or a problem, or should. She's familiar with how to use Zoom and knows to keep her stuff on me, so. I mean, for coordination's sake, I wish the state would have provided me with their Zoom code, if this is how it's turning down, so that I can contact the current advance and not use it for time.
Let's see if we can bring it together or not. Your witnesses are also not within Collier County, is that correct?
Yes, Your Honor. The witnesses in Texas.
So at this point, Mr. Ashby, it appears that we may have Mr. Eno Folsa.
Yes, that is, Ms. Espinosa is the state witness.
Is there any way for Ms. Rios to access and this particular connection, or is that something that would put the state in an uncomfortable position in terms of granting access on its system?
Somewhat, Your Honor. This is the state's created Zoom link for our witnesses so they can appear remotely. my understanding that defense counsel has their own Zoom code and has I believe it's the TV monitor here, actually, for them to have access.
How did the state perceive that this was gonna be conducted in terms of, there were gonna be 2 screens?
That's my thinking, Your Honor. Obviously, I learned that defense counsel intended to have the defendant appear remotely, and that they had a Zoom code. My understanding is that they were essentially going to have a screen with the defendant appearing remotely. When I received the information that they had coordinated with court admin to have the monitor here, my understanding that they were prepared. I can't.
So the state typically does not grant access to its Zoom codes for this type of purpose.
Correct.
It's what you only granted for your witnesses and things like that?
Correct.
And Ms. Stevens, what was your impression going into this as to how this would all be done?
Well, I didn't have an impression as to how it would be done. Unfortunately, I received notification when I was looking for Zoom codes, from your judicial assistant last week. Because I was under the impression that we were all in agreement that these witnesses would be appearing remotely, and that myself and the state would be here. Predominantly based upon the fact that Israel was pregnant and was having complications. So we weren't sure if she'd be in the hospital, if it was liver, if the baby be here, we didn't know what the circumstances were on the day.
Well, at this point, you don't have anything set up for her to monitor or participate at this time, is
I
that
don't,
correct?
I don't want to use my cell phone to do this because I don't think it's fair to Ms. Rios, because she should be able to hear what other people are saying.
Now, is Ms. Rios in a health condition such that she could, if we are not able to go forward today, is she able to be present in court?
My concern is that she now has a newborn, the baby is very young, she was a health risk, and so without divulging her personal medical issues to the court or to the state, I would need to check with her physician to find out if she's okay. And then my other concern is, number one, Ms. Rios does not drive. She has to be driven places. So she does not have an active driver's license. That was the other reason why, it was important to coordinate. Number two, my concerns are obviously we're still not 100% clear for pandemic. She's a brand new baby. I don't want to put her or the child at any sort of risk. Again, this is why Zoom was created by us. So when we reached out to your judicial assistant, we didn't hear back until Friday of last week, unfortunately, that Your Honor did not have a code for this purpose, that it was something that we would have to coordinate. I didn't even know about a laptop issue until this morning. And I didn't even know that there would be, basically what I'm saying is there was no coordination with the state attorney and myself as to how this meeting was received. All I got was, yeah, the state agrees that we both said it's just remotely. That's it.
Well,
oh, by the way, you have to arrange that yourself.
At this point, I'm not inclined to require the state to grant access to its Zoom code. I think there may have been a failure to communicate in the sense that traditionally the attorney presenting the witness is responsible for the Zoom arrangements, separate from the court and separate from opposing counsel unless there's coordination. I understand Ms. Rios, her health condition at this point may or may not affect her attendance personally.
Yeah.
That's why I was willing to have her remotely, but it does not appear we can go forward at this time based on the way we're situated. I'm certainly willing to set it for a prompt date where either Ms. Rios is here in person or Ms. Stevens, you'll need to arrange for a separate connection for her to appear remotely. I will, if as an officer of the court you're indicating that there's a concern with her appearance because of her recent childbirth, but I would put that responsibility upon you to either have her here personally or arrange a separate appearance from her remotely. So let me go ahead and reset this now, Mr. Ashby, because I don't think we can go forward in this format today.
Your Honor, if I think the defendant be made available by Zoom on counsel's phone.
I don't think she's going to be able to hear Mr. Joseph, that's my problem, and it's a due process issue. without the two of them, I mean, when we all appear in court, Your Honor, every single person is on the same call.
Now, let me just ask for the future, if we have two screens in here, Mr. Ashby, one with the defense Zoom code connection and the other one with the states, is that going to be adequate, or do we need something that's a combined connection?
My understanding, it may very well be adequate. The preference of the state would actually be to have the defendant here in person. This is a bond hearing. So, depending on the court rules, the defendant is either going to remain out on bond, or the defendant is going to go into custody for a violation of the conditions. Seeing how there is at least there's two options. One is 53% odds that the defendant is going to be going into custody. The defendant should be here present. It does raise concerns if the defendant is not here. The court rules that the defendant should be taken into custody.
Well, I think there is my understanding, and I was accepting as an officer of the court from Ms. Stevens, that there was a very recent childbirth. But as time passes, I think the state's position is more persuasive, and that is, Ms. Stevens, I think that given the nature of the hearing, I don't think we can go forward today, but given the nature of the hearing, I will require her personal attendance unless the defense presents medical verification that a physician indicates it would be deleterious to her health to be here in person. That does not mean I would not address the matter remotely and make a decision on the state's motion, which would then be effectuated by either an order to surrender for custody or by a pickup on a warrant. But that's getting ahead of ourselves because we don't know what the bond motion result will be. But at this point, I think it will make, as time passes, it is more appropriate that she be allowed or required to be here unless there's medical verification presented that she cannot.
I can advise the court, Your Honor, and I'm sorry for the disruption, but she just sent me an email that says that her son is 3 weeks old and has not left the house, but has only gone for one checkup with the physician. She does not feel okay leaving that newborn with somebody because she doesn't want to leave the child alone because he's so new. I have no problem, and I did provide the state with my Zoom code to allow their witnesses to appear. I set it up in my Zoom. I have no problem with them logging on to mine and having their witness log on to mine. That's a private Zoom code that I established. I forwarded to the state. I figured everybody could use it. So.
Well, I think at this point, we're going to be setting something in the next 30 days.
Yeah.
And I will require the defendant's presence unless there is a medical excuse from a physician indicating that it is harmful to her health to be present for that. So let me go ahead and set that date now. And I understand there may be hardships, but she'll have to make arrangements. She'll have enough time to make those arrangements. The state's witness can be remote.
Judge Manalich's office.
Hello, Melissa. We're going to need to reset the Rios hearing. I do want to do that within the next 30 days, but probably not sooner than 2 weeks because I do want the defense to be able to plan. So we're probably looking at 3 to 4 weeks out. 3 to 5 weeks at the very latest. And about how much time was reserved for today? 30 minutes?
I believe so, yes.
So 30 minutes, Melissa? And we'll try to get confirmation. I've made clear that unless there is medical verification excuse that Ms. Rios will need to be present in person. If there is a medical excuse and she is going to be remote, Ms. Stevens will need to make arrangements for a screen and a connection separate from the states. Do you have a date?
Just hold on one second. I just need to look at something to make sure I'm not looking too much. How about July 21st at 9:30?
Let's check with counsel on that. Now, the other thing is, do you have an afternoon time, Melissa, since I believe Ms. Rios may be coming from out of county if she's going to be here in person?
How about that same day, Wednesday, July 21st at 3 o'clock?
That may be better, I think. Gives everybody time to be here. on that date. Mr. Ashby, any problem with that?
One thing, Your Honor.
Okay. And do you know if there'll be any issue for Mr. Hinojosa?
So, Your Honor.
Let's check if he make sure he doesn't have something planned that day, that I do want to be sensitive to his schedule also.
Ms. Hinojosa, can you hear us?
Yeah.
The court is resetting the hearing. Are you available on July 21st at, was it 3 o'clock now?
Yes.
At 3 o'clock?
Yeah, that's fine.
Thank you for your cooperation. So everybody is available then?
Yes, and the only request that the defendants would have is I noticed that today, Ms. Conjosa is actually appearing without actually appearing. In other words, there's no way for us to actually see.
No, I think she'll be visible when we have the hearing. Is that correct?
Your Honor, in follow my instructions, I told her to both mute and lock.
Right, no, but obviously once we start the hearing, then if anyone's participating remotely, have to be fully visible and audible.
And that's just for confirmation
Right.
purposes. So.
All right, so I think we've discussed everything. It's set. All of the ground rules have been set. And look forward to seeing everybody on that date. Thank you for your patience, Ms. Hinojosa.
So Judge, these cases don't have any upcoming.
We'll have a case management on that date also. All right, that concludes this matter. Thank you. Still doing a lot of Lee County work, Ms. Stevens?
Yes, I am actually.
Okay.
I'm doing many fires, moving blades, and so lucky me, I'm on